Okay, looks like we're ready to start with case number 34, Gambrill versus Board of Education. And I understand, Mr. Hansel, you've reserved 5 minutes for rebuttal.
Yes, Your Honor.
And Mr. Scott, you'll have the usual 30 minutes.
Yes, Your Honor. Thank you.
Okay. Mr. Hansel, you can proceed.
Thank you. Good morning, and may it please the court. My name is Cary Hansel, and I represent the Gambrill family, Brandon, Robin, and their young daughter. This case is about a young girl who was attacked more than a dozen times in school. She suffered 2 concussions, bruises, welts, bleeding. She had her hair ripped out. She was stabbed in the leg with a pencil. The Court of Special Appeals characterized all of this as horrifying. It happened in front of teachers who failed to intervene or protect her. It happened when an administrator knowingly left her alone with an attacker who had previously assaulted her. It happened at a dance where she was assured the attackers would not be permitted. The case ultimately is about a failure to protect and whether the courthouse doors will be closed to victims like this in the future. The negligence claims were inappropriately dismissed against the individuals based on the federal Coverdell Act's liability limitation. But the Coverdell Act expressly permits states to adopt statutes that shift liability from a teacher or teachers to a board of education, and such statutes under the Act, quote, shall not be construed as inconsistent with this section. That's 20 USC section 7946B2. There is almost no analysis of that section, which is the critical issue on appeal in the defense's briefing, for good reason. Maryland has taken advantage of exactly that exception under Coverdell and has indeed passed section 5518H of the Courts and Judicial Proceedings article, which does shift liability from board employees to the county board, requires that the county board be a party to the case, bars collection from board employees, and requires that any judgment be levied against the county board. So that dovetails neatly into the exception in the Coverdell Act. The Court of Special Appeals erred by interpreting the Coverdell liability limitation as an absolute immunity from suit. And in this way, they were able to then suggest that the state statute somehow did not fit into or dovetail with Coverdell. But Coverdell is not an absolute immunity from suit as suggested by the Court of Special Appeals analysis. Instead, the statute talks about liability, quote, no teacher in a school shall be liable if many conditions are met, not immunity or the type of immunity from suit that might be required by a state statute if that were the language of Coverdell. And so fundamentally, the Court of Special Appeals misinterprets Coverdell, sets a high bar that is over and above the statute of immunity from suit, and then suggests that because state law does not permit for total immunity from suit, it is incongruous with Coverdell. That isn't the case because, again, Coverdell focuses on liability, not immunity from suit. The other courts that have looked at this issue, when called upon to weigh whether there is an immunity.
Can I ask you,
Yes,
it's your argument that B2 of Coverdell that says state law that makes the school or governmental entity liable for the acts to the same extent as the employer is liable, that's an exception and that the Maryland statute fits into that?
Precisely so, Your Honor. Yes. And the Maryland statute dovetails quite neatly, particularly in a case like this, where we're talking about negligence of employees that dovetails almost precisely into that language. And that's why in the 20 years since Coverdell was passed, this court has never held, nor has any appellate court in the state until this case ever held, that Coverdell immunity applies to trump Maryland law in some way. In other words, the Court of Special Appeals, for the first time in Maryland history and in the 20 years since Coverdell was passed, has in effect read section 5518H out of Maryland law, because it would, in the Court of Special Appeals' opinion, be contrary to Coverdale and therefore bar any liability that the legislature in Maryland clearly anticipated. And the other courts that have looked at this question have held that there is not an immunity from suit in Coverdale, but instead a liability limitation, and therefore applying those holdings here, it would track perfectly with Maryland state law. In that regard, we've cited Stephan and Walker from Kentucky. We've cited Sanchez from Kansas. Again, there is no Maryland precedent on these points. So what we have here is a case in which Coverdale explicitly permits the state to do what it's done, to assume liability for the individuals, and therefore Coverdale immunity does not apply.
But could a Coverdale defense go to litigation if there is a dispute about some of the exceptions or conditions that are attached to Coverdale?
Yes, Your Honor, it can and should. So for instance, in this case, if there were some path around the argument I've just made, and I don't think there is, the next question would be, are the elements of Coverdale met? The courts that have looked at this have held it's an affirmative defense, that the defense has to affirmatively meet those elements. One of them that's easy to look at is that the state has to receive very particular funding in the years in question under Coverdale. And here, there was no evidence below, none whatsoever in the record, that that funding was received. The Court of Special Appeals went beyond the record, searched the internet, and tried to find some funding, and further erred because the funding cited by the Court of Special Appeals is under subpart 2 of Part D of 20 U.S.C. 70, which is entitled Local Agency Plans. That is funding that flows directly to local agencies. If you look at the sites that the Court of Special Appeals used, you'll see that we're talking about funding for the county, not the state. The funding that triggers Coverdale, the Coverdale liability limitations is found under subpart 1, not 2. Subpart 1 is entitled State Agency Programs. That's the funding that goes to the state. So what you have before you is my office has looked, the defense has obviously looked, the Court of Special Appeals looked. And the best anyone could come up with is the Court of Special Appeals found funding directly to the locality, which is not the type of funding under subpart 1 state agency programs that goes to the state and that triggers Coverdale in the first instance. So
Mr. Hansel,
yes,
do
sir.
we even need to address this funding issue if the court were to agree with you that the Coverdale Act does not create immunity from suit, and that the courts and judicial proceedings provisions in 5515 are exactly what's contemplated by subsection B of the Coverdale Act?
That's an excellent point, Your Honor. The answer to your question is no. The court, in fact, needn't reach any other issue raised by the parties because the claims against the individuals were dismissed only on the question of Coverdale. So once we find that section, that the Maryland statute satisfies Coverdale, that's the end of the analysis in connection with the claims against the individuals and in connection with the statutory liability on behalf of the county, because the trial court did not grant summary judgment to the individuals on the merits and could not have done so because of all the factual disputes. The trial court did not grant summary judgment to the individuals based on Hunter. The language is very clear. The trial court's analysis of the claims against the individuals turned only on Coverdale, and that is the issue that's properly before this court.
Well, is there a difference though, and maybe the cost to defend is covered elsewhere for the employee, but is there a difference between the cost to defend that the teacher would incur, and is that a factor here as opposed to indemnification?
So, Your Honor, where that comes into the law is where we see immunity as opposed to limitations on liability. Coverdell is a limitation on liability, not immunity from suit. And the analogy I draw, for instance, is in the case of qualified immunity in federal court for claims against police officers, that has been repeatedly held to be an immunity from suit. An immunity from suit encompasses the types of concerns that Your Honor is discussing related to the costs of defending oneself. But liability limitations do not encompass those types of limitations. And when courts have been asked this question in the past, Stephan, Walker, Sanchez, the cites are in our briefs, the finding has been that this is not an immunity from suit, but a liability limitation. And keep in mind, it isn't, and we know that because the statute talks about liability, not immunity. And even the limitation on liability, which is the language of the statute, is very narrowly constrained. So there's about a 5-part test, and the defense has to thread the needle all the way through all 5 parts. We only mention funding because, as Judge Booth points out, I don't think we need to get past the question of, isn't it the case that the Maryland state law dovetails perfectly into Coverdell? And once that holding is made, there really is nothing further for the court to do because, Your Honor, Coverdell talks about a limitation of liability, not immunity from suit. It is when we get into immunity from suit that we're talking about costs of defense. Now,
so, Mr. Hansel, are you suggesting that if we address the Coverdell issue, we don't need to address the discussion in the Court of Special Appeals opinion about the Hunter extension of the Hunter doctrine?
Well, there's a distinction, not as to the individuals, because if you look at the trial court's opinion, the individuals were dismissed on Coverdell only. So once if the court were to find that the Maryland state statute satisfies Coverdell, those claims are back because that's all the trial court found. It's all the trial court could have found because this case is littered with factual disputes. The defendant's brief goes on and on in footnotes, just illustrating the factual disputes. In this case, it's a brilliant job of showing why a trial is necessary here on the factual questions. However, Judge Booth, once we move to the liability of individual board members or the liability of the board as a body, not the liability under Courts and Judicial Proceedings 5518, but in other words, not the indemnification of the teacher, but the liability separately, directly, then we go into Hunter. And the answer to the Hunter line of cases is quite simple. We start with Hunter itself. In Hunter, the court held that there's really no such thing as educational negligence involving claims relating to academic decisions like, quote, improperly evaluating, placing, or teaching a student, or that type of thing. That isn't what this is about. This is a failure to protect a child in the charge of the government. It's no different than the failure to protect a prisoner, an arrestee, anybody else who's in the charge of the government. And the cases cited under the Hunter line talk about educational decisions like whether or not to place somebody with learning disabilities into a particular program. So Hunter, for instance, involved negligently evaluating someone's learning disabilities. That isn't what we're talking about here. We're talking about teachers who saw a child being attacked and did nothing to protect the child. Now, the defense tries to shoehorn what happened here into decisions about discipline, which they then argue are academic matters. First, Hunter's never been extended to include discipline, but more importantly, before we get there, I want to stress to the court, this is not a case about discipline. We're not claiming this child, as amicus is concerned about, the attacker should have been expelled. That isn't the argument here. The argument is the young woman here, a 12, 13-year-old child, should have been protected. We might protect that child without any discipline at all. So a failure to protect claim is not a claim that raises concerns only about discipline. Simple examples include there might have been a monitor added to the classroom or the hall. That has nothing to do with discipline, a person to stand there and ensure the child's safety. There might have been separation of the two children put into different classes or on a different schedule. That has nothing to do with discipline. It's just protecting somebody's safety. There might have been any number of solutions that are non-disciplinary solutions. So even if, Hunter, we're going to be expanded for the very first time to include discipline, this case isn't about discipline. It's about a failure to protect. But Hunter shouldn't even be extended to include discipline, because that is the type of creep that begins to eviscerate what the legislature has done here. The legislature has allowed for liability and shifted liability to the government. If we expand Hunter to include discipline, there's at least as defined by the Court of Special Appeals and as defined by the defense in this case, there's precious little that would be left, and we'd be closing the courthouse doors to victims. So for instance, a failure to discipline, if this case is one, would include almost any harm that might happen to a child in school at all, because almost any harm you might imagine would likely be resolved one way or another through discipline in the school, right? So any child on child issue suddenly becomes an issue of discipline and is barred by Hunter.
It's about disciplining the attackers.
Yeah.
Of the client.
Yes, Your Honor, but Hunter doesn't go that far. But even if it did, my point is here that no, we're not challenging the failure to discipline only. We're saying there should have been some protection. So you might do that short of discipline. And back to Judge Raker's point, I'm sorry to loop back, Your Honor, but Judge Raker was concerned about the costs of defense to the teacher. One thing I'll stress, and I've done this work for 20 years and had a half dozen or more cases against school board members and teachers and all types of school personnel, I will stress that not once have I ever seen a teacher have to pay for the cost of their defense out of pocket. That is also, as a practical matter in Maryland, in every case I've ever had, covered by the government one way or another. It's either through the local government insurance trust representation or through the town or county attorney rather. So even costs of defense as a practical matter in Maryland as a reality are in fact absorbed by the employer. To get back to Judge Raker's.
Could I ask you another question?
Yes, please.
Your first question presented talks about preemption. Is this jurisdictional that we're talking about, or is this an affirmative defense? And can this be waived?
So the courts that have looked at that question have held that it is in fact an affirmative defense that not only can be waived, but that the defense must bear the burden of proving. So I offer in that regard, as it relates specifically to Maryland, and this is a federal case, Doe versus Board of Education of Washington County. It's from 2015. It's from the United States District Court for the District of Maryland. And there's a quote in that case, quote, immunity under the Coverdell Act is an affirmative defense in which Robinson, who was the defendant there, bears the burden of proof. That's right here local, but also across the country. Webb versus Clark County School District out in Nevada suggests Coverdell is, quote, an affirmative defense that must be pleaded or it is waived, to get precisely to Your Honor's point. Monroe.
It's not jurisdictional, obviously.
No, Your Honor. Likewise, Monroe versus Preston Christian Academy out of Texas. The act applies only in states that receive funds under this chapter. I'm sorry, that was Goal versus Turback was what I meant to cite. Michigan, there it also talks about the fact that this is an affirmative defense. So the courts that have looked at this have treated it as an affirmative defense, one that can be waived and one that is in fact not jurisdictional. And again,
the Court of Special Appeals seem to hold that Coverdell immunity preempts the statutory right of indemnity under Section 518. Preempts. What is your response to that?
Well, Your Honor, respectfully, the Court of Special Appeals erred, and the courts that have looked at it have not treated it as preemption, and it clearly isn't structurally. And here's why we know that. The Coverdell Act explicitly permits states the freedom to do what Maryland has done here. The act does not say there is federal preemption. Now, to take that a step further, there couldn't be federal preemption because it's really not a question of preemption where the Constitution has assigned to the federal government the right to dictate the rules. This turns on the acceptance of funding. So it really isn't a preemption issue to begin with. But even if it were, the Court of Special Appeals erred in so finding because the act specifically permits what was done.
Both Coverdale and 5518 are defenses for teachers.
I think that's correct, Your Honor.
Is it then up to the teacher to determine which defense they wish to pursue? Could they try both? Now, the Court of Special Appeals said no because 5518 is gone, it's preempted. Is there any life left to it in your view? And if so, what?
Well, if the Court of Special Appeals opinion is allowed to stand, then that statute is effectively eviscerated. There's no life to it. And that's one of the reasons why the Court of Special Appeals opinion should be overturned, because it's contrary to the legislative intent of that statute. It's pretty clearly expressed legislative intent that there be liability with the school board under appropriate circumstances.
Does it make any difference that 5518 has a money $400,000? That's a cap. Now, that's not involved in this case because they didn't sue for more than $400,000. But does that make a difference? And if so, what? Coverdale doesn't have that kind of a limit.
So the answer is I don't think it makes a difference at all. It's not an issue here before the court today, but I don't think it makes a difference at all for this reason. Coverdale does not say you have to do exactly what we want you to do. Coverdale says you can make it more restrictive if you want to. So it permits states, for instance, to do things like cap damages. So I don't think there's an argument that Coverdale uncaps the damages here. As much as I would like that to be the case, if you were going to hear that from anybody, it would be me in these circumstances. But there isn't that argument, because what Coverdale does is allow the states to be more restrictive as to the liability limitation. And I view the cap that exists in state law as being, I think, indisputably more restrictive. And that therefore, again, dovetails perfectly into what Coverdale permits.
And Mr. Hansel, my understanding of Courts and Judicial Proceedings, Article 5518, and specifically subsection E, is that an employee is not personally liable for any judgment or damages in excess of the governmental cap. Am I correct?
That's correct, Your Honor. And it's also true that absent the very rare circumstances of malice or gross negligence, the judgment can't be levied against them at all. And those circumstances, of course, aren't at issue here because we're talking about negligence. In this case, count 5 was our negligent claim. So again, the count fits perfectly into 5518 under Maryland law. 5518 fits perfectly into the exception under 7946B2 in Coverdale. So we have in lockstep the ideal case for Coverdale exception. And it's no surprise that that's the case because Coverdale's been around for 20 years and this defense has never succeeded anywhere as far as I'm aware, but certainly not at the appellate level before, precisely.
Mr. Hansel, do you want to take an opportunity to address the claim that the board's liability under the Hunter case is not before the court because it wasn't included as a question in the petition?
Yeah, so if you read the petition repeatedly talks about the fact that this opinion would immunize both the board and the teacher, and that's impermissible. That's on, I think, literally every page of the petition. So I think we did properly raise that issue. But as to the individual teachers, the court needn't reach the Hunter question. And that really ultimately is the heart, I think, of the appeal. And you needn't reach it because the court only dismissed the individual claims under Coverdell. So really, the heart of this case is about Coverdell. We only get to the Hunter question when it's raised by the defense really as an alternative argument that they're trying to raise. So it needn't be in my cert petition when somebody is going to raise it against me as an alternative argument, because I'm not in the habit of appealing things that the trial court did not rule. The trial court didn't dismiss the individuals on Hunter. Instead, it dismissed the individuals only on Coverdell, and Hunter's raised as an alternative defense. I see that my time is up, but I'm happy, obviously, to answer any additional questions. Thank
Any
you.
other questions at this point from the court? Okay, we'll proceed to Mr. Scott then.
May it please the court, Andrew Scott on behalf of the respondents. The only issues properly before the court this morning involve the Coverdell Act, and those two issues are as follows. One, whether the Coverdell Act provides immunity from suit as opposed to immunity from personal liability, and therefore preempts the right to indemnification under section 5-518 of the Courts and Judicial Proceedings article. And secondly, whether eligible defendants must offer evidence that their employer received relevant federal funding in order for Coverdell to apply. Those were the only two issues appealed or raised in the petition for cert. Those were the only two issues granted in this court's order granting the petitioner's petition for cert. We respectfully submit that Coverdell indeed provides immunity from suit, that proof of funding is not required, and that this court should therefore affirm the decision of the Court of Special Appeals.
But why isn't proof of the required?
Well, Your Honor, first of all, no court anywhere, contrary to petitioner's contention, has held as much. And in fact, all of the courts conclude the contrary, albeit implicitly. I think most notable probably is the decision from Judge Moss that Mr. Hansel cited earlier this morning, which is Doe versus Washington County School Board, a 2015 federal district court decision from this state, where Judge Moss granted Coverdell immunity to an assistant principal at a Maryland public school based solely on the satisfaction of those 5 conditions precedent, you might call them, in section 7946A of the Coverdell Act. He did not rely upon receipt of federal funding. We submit that the Court of Special Appeals decision was correct in concluding that the only relevance of federal funding is to demonstrate Congress's legislative authority to enact the Coverdell Act.
But if hypothetically, let's not make this Maryland, but if there's another state that has not accepted Coverdell funding, would the Coverdell Act apply to potentially displace state law claims in that other state?
Well, Your Honor, we have a fundamental disagreement with Mr. Hansel about whether Coverdell displaces 5518. And that's where I'd like to focus my attention because
Well, I'd like you to answer my question though, please. If in another state, my question on this funding is, assuming that a state can decline the funding, how would it come to the court's attention? Who has the burden to prove that the funding does exist and that Coverdell should be a factor in a case in the first place?
We don't disagree that the burden is on the defendant, Your Honor. We did plead Coverdell in our answer. We admittedly did not produce evidence at summary judgment of receipt of funding. Frankly, Your Honor, because we've asserted this defense in many cases over the years, and not a single judge in this state has raised the issue. It's never gone up on appeal, I suppose, because plaintiff's counsel never desired to bring it to the attention of the appellate courts of this state. So we don't dispute that it's the defendant's burden, but we would submit that really the funding issue is really kind of a red herring because, as the Court of Special Appeals concluded, this court can take judicial notice just as it did that the Maryland State Department of Education received a significant amount of funding under Chapter 70 of Title 20 of the U.S. Code and that it was a portion of that was dispersed to the Dorchester County Public Schools during the year in question. We cited to a publicly available report in our appellate brief, which admittedly the Court of Special Appeals didn't cite to itself. It cited to other sources to confirm funding, but we think the funding issue, frankly, is a really a moot point, because even if this court were to remand back to the district court, or the circuit court rather, for that issue, for what it's worth, the defense has no concerns whatsoever that we can set forth that evidence. But I'd like to get in, if I can,
Are
to
you
the fundamental
suggesting the court take judicial notice of something that is not in evidence?
Yes, Your Honor, and we cite case law in our brief to that effect.
So that's where you are, judicial notice.
On this appeal, yes. Your Honor, we have
Mr. Scott, before you get into the specifics of CJ 5518, have you come across any case where a court has interpreted the Coverdell Act as the Court of Special Appeals has, which is its complete bar, complete immunity from suit? And I'm looking at the language in the Kentucky Stefan case, where they seem to make the distinction between liability versus immunity.
yes, Your Honor.
Immunity from suit.
Right. The only court to consider the issue actually ruled in favor of the position that we take in that case, and that was the Supreme Court of Missouri in the Didell case, which we cite in our brief, which affirmed absolute immunity. Well, I shouldn't say absolute immunity, essentially qualified immunity, because it's dependent on those 5 factors in 7946A, but affirmed immunity in favor of an employee without getting into issues of funding, et cetera. And it also was a complete immunity. Granted, that court did not go into detail as to why it was absolute immunity as compared to some sort of lesser immunity. But I'd like to get into the legislative history, if I can, as to the Coverdell Act, which wasn't provided in our brief, which we contend is highly persuasive of the Congress's intent that this act provide qualified immunity subject only to satisfaction of those 5 factors in 7946A.
But it's not just
Well,
those
before
5 factors. I'm sorry, you got.
Go ahead.
Out there. It's also 7946D. I spotted a number of provisions in 7946 and that almost beg for litigation if they're raised as defenses.
Your Honor, I'm sorry.
That's
the subpart that you refer to is an exception to a limitation on liability, and there are several of those, including 7946B2, which Mr. Hansel focuses on extensively in his brief, in which we contend, we have a fundamental disagreement. We think Mr. Hansel respectfully misreads that provision, and it's of significant importance to this appeal. And so if I can jump into the legislative history.
Actually, before you jump into the legislative history, because usually this court starts with the plain language of the statute, I have a few questions about the plain language, because if we determine that the plain language controls, oftentimes we don't get into that legislative history. So when you look at the statute in subsection A, preemption, the statute specifically says the law preempts the laws of any state to the extent that they're inconsistent with this subpart. And then it says, except the subpart shall not preempt any state law that provides additional protection. And then you go to subsection B, and also under the plain language, I don't see the word immunity used one time in this statute. And under subsection B, it specifically says this statute will not be held to be inconsistent with laws of the states that limit teacher liability subject to one or more of the following conditions. And subsection B says a state law that makes the school or government entity liable for the admission of teachers. How is that not CJ 5518 on its face? The statute specifically carves out an exception for the very statute that the General Assembly has passed here.
Your Honor, I have a number of responses. First of all, we concede, if you will, that the language of this statute is not unambiguous. I think the Court of Special Appeals concluded as much, granted implicitly. We
The
argued
Court
as
of
much.
Special Appeals didn't even analyze. I don't even think they call out subsection B.
They don't, but the court, by virtue of comparing the language of Coverdell to 5518, implicitly is conceding or concluding that the language of Coverdell is ambiguous. Otherwise, there'd be no reason to go beyond the plain language of the statute.
But if we conclude that the Coverdell Act is unambiguous, we don't need to go beyond the plain language of the statute, do we?
No, pursuant to ordinary rules of statutory construction. But I would contend that it would be virtually impossible for this court respectfully to do that in light of this court's analysis in one of the seminal cases in this appeal, which is Mark Sloan versus Board of Education of Prince George's County, where this court held that the language of section 5518 itself was ambiguous and therefore looked to the legislative history and looked to comparable statutes, et cetera. So we contend that there's really no way to conclude that the language is unambiguous in favor of the construction that petitioners are advocating.
I have a question, perhaps related, but as the sections we were just talking about, or you and Judge Booth were just talking about, 794, 77945A starts with preemption of inconsistent state statutes. So the first step is, are they inconsistent? Then you compare, then if they are inconsistent, then you compare what happens under each statute. And as was just pointed out, B2 seems to say 5518 is not inconsistent. So you never get to comparing the 5518 to Coverdell because Coverdell says they're not inconsistent in the first place.
Well, Your Honor, let me address that issue. So petitioners read 7946 B2, which is that states can enact vicarious liability statutes, and those statutes are not inconsistent with Coverdell. That's how petitioners read it, that section is not inconsistent with Coverdell as a whole. But if you look at the plain language of 7946 B, before we even get to B1, it says that if the laws of a state limit teacher liability subject to one or more of the following conditions, such conditions shall not be construed as inconsistent with this section, not this subpart. And I think that's a very, very crucial distinction to make as it relates to the construction of this entire Coverdell Act. So the B2,
B2 is what you're focusing on?
well, the language I just read is subsection B before you even get to B1. It's sort of the introductory sentence of B. So in other words, B2 envisions that state legislatures can pass vicarious liability statutes and that's not inconsistent, but only not inconsistent with this section, meaning the liability on limitation of teacher section, not the preemption section at 7945A.
Well, if we construe it in the way that you are suggesting, the whole subsection B would make no sense. It would have no application or connection. You have subsection A is liability protection for teachers and B is exemptions. So if we construe it in the way that you have suggested, why would subsection B be there at all?
Well, the reason it's there is because there are several prerequisites that have to be satisfied for Coverdell to apply at all under 7946A. There's those 5 prerequisites, which are not in dispute in this case, by the way. So in other words, a state could pass a vicarious liability law that provides greater protection than 7946A. And moreover, the enactment of a vicarious liability statute by a state reaffirms or supports the legislature's intent that this statute provide immunity by virtue of confirming that a school board can still be vicariously liable, even if an employee can satisfy the prerequisites of 7946A. In other words, vicarious liability as to a school board is not inconsistent with qualified immunity to an individual employee as long as they satisfy those 5 elements, and that's why it's there. A state, for example, could pass a vicarious liability statute which provides greater protection than set forth in 7946A.
Mr. Scott, do you have any case law that interprets Section B, the plain language, the way you just described it to us?
No, Your Honor, and there's not much case law on Coverdell in general, as evidenced by the fact that Mr. Hansel and I generally cite to the same cases and have done so throughout this litigation. This case is an issue of first impression, and I can see that this would be basically a novel ruling, at least in a reported decision of a state high court. But that distinction is crucial because, first of all, we don't concede that 5518 falls squarely within 7946B2. 5518 is not a vicarious liability statute. It's only an indemnification statute, as this court made clear in the Mark Sloan case. It does not shift liability, as Mr. Hansel has contended. It only shifts responsibility for the financial burden of a judgment entered against the school system employee. But setting that aside, because 7946B2 only applies to that section pursuant to its plain language, i.e.
So if it only applies to that section pursuant to its plain language, it would basically say, this is a section that if a state passes laws pursuant to it, those laws are not inconsistent with this section.
Right. So in other words, it's not inconsistent to have vicarious liability asserted against a board while the underlying employee is immune pursuant to federal law.
How would that reading in any way fit into the structure of the act, considering the preemption language that speaks to whether the state passes laws that are inconsistent with the act, not a certain section of the act?
Well, Your Honor, to the extent that Congress chose to use the word section in 7946B and uses subpart in 7945A, we think that's a deliberate distinction. And,
Right.
and moreover, Your Honor, I think the legislative history indicating that this act was intended to provide essentially qualified immunity is further evidence to support our construction of this statute, not to mention cases interpreting a virtually identical federal statute. In fact, a statute that Coverdell was modeled almost identically on, which we think is highly persuasive. And I certainly want to raise that case to the court.
I understand, but I didn't really see the legislative history covered in your briefs. Perhaps I missed it.
They are not, Your Honor.
All right. So if we focus on the plain language, I don't think the Court of Special Appeals found that there was any ambiguity with respect to either the words inconsistency in the preemption subsection or to the language regarding no teacher shall be liable. It just seemed to be a conclusion by the Court of Special Appeals that this meant immunity, but I did not see a finding of ambiguity. Don't you agree the Court of Special Appeals did not find ambiguity?
Not expressly.
Right.
I would agree with you that. I would, but implicitly, otherwise there'd be no reason to look at 5518, which is what the court did. It said 5518 pursuant to Mark Sloan only provides for indemnity, and immunity is greater than indemnity. Therefore, Coverdell preempts 5518.
Yeah,
Well, we would look at 5518 necessarily to determine if it's a state law that is consistent or inconsistent. That is in no way any indication of ambiguity. That's our obligation in interpreting the plain language of the Coverdell Act, right?
I would agree, especially as to the preemption issue.
All right. And I'll just-
the Court of Special Appeals, as I read that opinion, regarded 5518 as providing the teachers only with indemnification, whereas Coverdell provides immunity. Now, is that correct in your view?
It is, Your Honor. And granted, as Judge Watts said, the court didn't expound on how it got to that conclusion.
right.
But to the extent this court reviews that decision de novo, we think that the legislative history is highly persuasive as to what the legislative intent, which is the cardinal rule of statutory construction. I'd like to, if I can, briefly touch on that, if only to reference the citation and the case name of the opinion interpreting it.
I just want to compare the language in our Maryland Tort Claims Act, which provides qualified immunity for state personnel. And it specifically says that state personnel are immune from suit in courts of the state and from liability. So that's an explicit plain language grant of immunity that a deliberative body, a legislative body, knew how to confer, and Congress in passing Coverdell did not use that language.
I agree, Judge Watts. The key difference is that we're talking about two different legislatures. So the General Assembly certainly used clearer language in the Maryland Tort Claims Act. Congress chose to use different language in the Coverdell Act. So
but Congress did not choose to use the word immunity. It says they shall not be personally liable. These seem to be liability protection provisions, kind of not unlike our indemnification statute, if we want to call it that. I guess I'm struggling with looking at the statute, the structure, the plain language, how there's any reasonable interpretation that it's immunity from suit.
Your Honor, as I said earlier, we think it's ambiguous, and we therefore need to look at the legislative intent. That's the first rule of statutory construction. What was the legislature's intent in enacting this statute?
And that's not right. That's not really have been presented to us. It's before us, but it hasn't been presented to us at this point, has it?
Well, we're presenting it this morning, Your Honor. And it exists. I mean, I think it would be, I don't think there's any case law that I'm aware of that would preclude counsel from raising authority at argument that wasn't raised in a brief. It frankly was discovered in preparing for oral argument. And it's significant.
Well, aside from whether the money was produced, what, if anything, did the legislature have to do with respect to Coverdell? Did it do anything?
The legislature has not, our legislature has not, as evidenced by the Court of Special
Appeals. Taken that federal law without blessing it?
Well, the statute is set up such that the states can reject the immunity provision.
They can.
Which our legislature has
do a
done.
number of different things there, and they really haven't done any of them, have they?
They have not. They have not. But by operation of law, the law therefore applies, and that was the holding of the Didell Court, the only state Supreme Court, aside from this one, to have considered the issue.
Before you talk about Didell, by operation of law, one thing they could do is simply leave, and I haven't looked to see which statute preceded which, but if CJ 518 is on the books and you accept an interpretation, and I appreciate that you're not conceding this, but you accept an interpretation that falls within 7946B2, they wouldn't need to do anything, would they? They would simply have a state law on the books that is not inconsistent under the plain language of the preemption provisions in subsection A.
Well, Your Honor, not if the inconsistent language from 7946B doesn't apply to 7945A, the preemption provision.
But if we assume for the sake of argument that it does, and I realize you're not conceding that, the General Assembly wouldn't have had to do anything to avail itself of that exception.
I suppose that's correct, Your Honor. If the court were to construe 7946B as, well, if this court were to construe 5518 as falling squarely within 7946B2, but again, we contend that it's not a vicarious liability statute. It's merely a shifting of the financial burden.
Well, isn't it partly an immunity, the 5518 partly an immunity statute, and that if you get above 400,000, they're basically immune, right?
It is a partial waiver of sovereign immunity in that respect, yes.
Or no, immunity for the employee. And it's a partial waiver of sovereign immunity for the board. It's a shifting of liability from the employee to the board for judgments under 400,000. And once you get above 400,000, unless it's, I guess it's malice or gross negligence, and then it's just the employee themselves, I take it.
Right.
It's immunity for the employee, right?
Right.
Well,
So-
it looks like 5518 was enacted in 1990. I'm just looking at the statute,
As we
chapter 546.
look at section A, if section A of the Cloverdale Act provides for immunity, even qualified immunity, why would we even need section B, exceptions to teacher liability protection? Because there wouldn't be liability once the factors in A are met. So we wouldn't even need B. So
Well, I think it's your honor to emphasize again the reality that we don't contest, that school boards can nevertheless be vicariously liable, and that Coverdale doesn't apply to the employer. In other words, it doesn't preclude a remedy as the petitioners are arguing in this case, albeit in conjunction with the Hunter and Urbani line of cases. It's basically affirming that Congress intended for there to be qualified immunity for individuals, but nevertheless liability for school boards at the same time. That
there's absolutely nothing in B that refers to the school boards, this concept that you're advancing now.
Well, the language of making the employer liable for the to the same extent as the employee is what I'm referring to.
Right, but in terms of speaking of liability, it focuses on the employee's liability. And so if there's immunity under A, we don't need a subsection B that discusses making the board or the governmental entity liable instead of the employee.
Well,
Because the employee is immune.
Are
I'm
you
sorry,
looking
Aaron,
at
what was the last?
79
The employee would be immune.
Are you looking at section 7945?
I'm looking at 7946 A and
Oh,
B.
46, okay.
A and B. And just suggesting that if A provides for immunity, we wouldn't really need the provisions in B to address any liability.
Your Honor, if I may, given the dwindling of my time here, if nothing else, then to provide the citations. 147 Congressional Record, pages 1338 to 1340.
I'm sorry, can you repeat that? I'm sorry.
Sure. 147 Congressional Record 1338 to 1340 contains the testimony of three of the co-sponsors of the Coverdale Act in Congress in February of 2001, where those senators indicate that they intend for this provision, for this bill, to basically constitute a qualified immunity statute. They reference the need to eliminate the distraction that lawsuits pose to the teachers of this country. And they specifically state what the bill provides and what it doesn't provide. And so when they talk about what it doesn't provide, they specifically reference to those provisions that are in 7946.
So that's the citation you have for us. Is that correct?
That is correct.
Okay.
And then-
did you share that with opposing counsel before the argument?
No, Your Honor.
I believe Judge Baran had a question.
It was going to be to give you an opportunity to actually tell us if there's anything in the legislative history that specifically zeroes in on this colloquy you've been having with Judge Watts. Is there anything specifically in the legislative history that supports your reading of 7946B that you've given us today?
Nothing expressly, Your Honor, but I think a fair reading of it supports the qualified immunity notion, which is separate and apart from the preemption issue in 7945A. And one other point, Your Honor, I referenced earlier the statute upon which Coverdale was based, and that is the Volunteer Protection Act of 1997, which contains virtually identical language. The Supreme Judicial Court 2 years ago in Lynch versus Crawford, which is 483 Mass 631, interpreted the Volunteer Protection Act to, quote, provide qualified immunity from suit, not merely immunity from liability, and went on to discuss findings in the VPA that are very similar to those in Coverdell, and said the liability risk is not merely the risk of being found liable and having a judgment entered against them as to volunteers, it's also the risk of being dragged into litigation and having to incur the considerable time, expense, and burdens of such litigation. A volunteer does not merely want to prevail in such litigation, the volunteer wants to end it. The First Circuit has cited to that Lynch case approvingly last year in Squarey versus Mount Ida College, that's 954 F 3rd 56, and the Southern District of New York several months ago in the case of America Broadcast Companies, Inc. versus Goodfriend, which is 2021 Westlaw 3910272, held that the Volunteer Protection Act is so broad, essentially, that it applies to cases where only injunctive relief is sought. And so, Your Honor, we would contend that.
Mr. Scott, I believe your time's up.
Thank you.
Unless there's a question from the court. Okay, Mr. Hansel.
Thank you, Your Honor. It's telling that counsel characterizes for the court precisely what he's seeking, and that is qualified immunity, which is immunity from suit. And that is what hangs in the balance. And we have seen across this country what a disaster that has been in other contexts. This court has never adopted qualified immunity, even for police officers, which is a federal doctrine that's in serious question today. More importantly, those words do not appear in the Coverdell Act. The word immunity isn't there, qualified immunity isn't there, immunity from suit is not there, immunity from having to pay to defend yourself, which in practice in Maryland is not an issue, but even if it were, does not appear. Instead, the statute, as the court has recognized, involves liability. Counsel, when asked if aren't there cases that demonstrate that this is liability rather than immunity from suit, said he wasn't aware of any. Well, we've cited the Stephan case, the Walker case, the Sanchez case. All of those rule on that specific point precisely, and we're in our briefs. Also, counsel cited to, when asked to do so, the Didell case. The Didell case is a case out of Missouri that does not analyze this question. There's some offhanded language in it, immunity versus liability. It doesn't appear to reasonably be raised there. The question in that case just involved different issues. There's some dicta there that counsel relied on. And that's true, even if you look at counsel's brief, Didell's cited in the funding section, not in the section regarding this question of whether there's liability or immunity from suit.
Would you agree or not agree that if there is a dispute between the parties, plaintiffs and defendants, with respect to any of the conditions stated in section 7946, that would have to be litigated?
Yes, Your Honor, of course.
So this is not an immunity from suit.
Precisely.
Putting these conditions on, it almost guarantees there's going to be litigation if the issue is raised.
That's correct, Your Honor. And if you look at those issues, they are, as Your Honor points out, precisely the type of thing that this court has repeatedly said must go to a jury. So for instance, one of the things is gross negligence. This court, the cases in this court are legion, saying that questions of motivation and degree of negligence are matters traditionally for a jury. The same is true in this specific case with respect to the funding issue. And here in this case, the defense cites cases in which no one contested it, in which, unlike here, the plaintiff did not stand up and say, wait a minute, we want you to prove the funding issue, to suggest that they don't have that burden. But in cases where it was contested, where it was raised, courts have repeatedly held that the funding issue is also an affirmative defense that the defense must prove. And critically, I want to stress that the citations from the Court of Special Appeals, and counsel didn't suggest otherwise, involve funds that are under the local agency plan under subpart 2, part D of 20 USC 70. Those are not state agency programs under subpart 1. So all the Court of Special Appeals was able to find was funding to the locality, which is not funding to the state, which is what Coverdell requires for the immunity.
Mr. Hansel, I want to ask you a question, just speaking hypothetically, and you discussed this earlier a little. Just speaking very hypothetically, if we were to reverse the Court of Special Appeals judgment on the Coverdell issue, but not reach the Hunter issue, and my understanding is the case is here only on count 5, this negligent education count. If we were to do that and then instruct COSA or the Court of Special Appeals to remand the case to the circuit court as to the individuals, what would happen in the circuit court? Would there be litigation, in your opinion, as to whether the Court of Special Appeals' judgment about Hunter still precludes the individuals from proceeding?
So in my view, Your Honor, the trial court, and not in my view, you can read the record, the trial court did not dismiss the individuals on anything other than Coverdell. So in many ways, my hands are tied because I can't appeal a ruling the trial court didn't make. So what I have appealed is the Coverdell issue as to the individuals. If this court,
but my question is, could conceivably the rationale of Hunter then be argued against the individuals?
it could be, but it would be a disaster for the defense because there are very clear factual disputes on those issues. That's not a matter for summary judgment. And you can look no further than the defendant's own footnotes to see that. They pick back and forth at almost every fact in the case. So there ought to be a jury question on where this fits on that spectrum between Hunter, which involves, quote, improperly evaluating, placing, or teaching a student, academic issues on the one hand, and general negligence, which is what our account is. And I want to respectfully, I'm sorry, Your Honor.
Your time's expired. If you want to quickly finish responding to Judge Watt's question, and then any other questions there may be from the court.
Thank you, Your Honor. Just the one additional sentence I wanted to say was Judge Watts, I think, referred to a negligent education count. And I want to stress that it's a negligence count, general negligence, which would include a failure to protect and things.
I agree.
Thank you.
I agree.
And I thank the court for its patience, and I'm obviously happy to answer any other questions.
If there are no other questions, we'll take a 5-minute recess.
Thank you.